To bring back in Bob Massi, a Fox News legal analyst for us as well, who spoke with us a little bit earlier. I want to talk about when we've got a case that potentially involves the death penalty and we've got a young woman sitting there in the courtroom. How do jurors deal with that?
Well, obviously they were qualified as a death penalty panel, so as a result, you know, they're in that mindset that based on voir dire and the questions that were asked, that in fact if the evidence meets that they will go forward with the respective evidence and make a decision. Also, Shannon, if I may, agreeing with much of course what the judge says, let's remember what rebuttal evidence argument is by the DA. The DA cannot rehash the argument again that they made at the beginning. It is exactly what it says. It is rebuttal only to those things that the criminal defense lawyer presents in their closing. So they can, although they will try, let me tell you, to sort of bootstrap their closing argument from the beginning, they are limited to what is said. Baez's argument at this point is a mitigation argument. It's the mitigation from premeditation. That's what his argument is. If he gets her off of the premeditated murder, some will say it's a victory. Conviction is a conviction. But the DA will be limited in what they can say.
And Judge, what do you make of her decision and or her counselor's decisions for her not to take the stand and testify?
Well, typically I would say that's absolutely the smartest thing they could do because, you know, I've tried at this point about 1,500 cases of all the criminal defendants that have taken the stand. Most of them get convicted, and usually because of the fact they took the stand. They make the state's case better. They look so bad, they get caught in lies. In this case, I'm not so sure it was a great idea because there was so much promised to the jury at the beginning. They were promised a specific defense that only Casey could testify to. They already knew that she was a liar and that she had prior convictions, which is one of the things that the defense tries to keep from the jury. So in that regard, she didn't have as far to fall as the typical defendant. So I'm not so sure it was a great idea, but I can see where the prosecution was going to rip her apart. This was a tough call because of the opening statements that were made. Yeah,
and Judge, you referenced those opening statements where a lot of people thought we were going to get a lot of different evidence based on some of the claims that her attorney laid out in that opening. Is it better to under-promise and over-deliver, or in this case, you know, raise some questions, at least among the jury, you have to imagine, as to why they didn't hear more about the claims that he made in the opening?
Absolutely. And Mr. Massi, I'm sure, will agree he would never have made that opening statement. That opening statement put a burden on them. Typically, the defense has no burden at all. The exception to that rule is that the prosecution can comment in closing argument on the defense's failure or at least the complete absence of any evidence of what was promised in opening when the defense gets up there and opens the door by saying, this is what you're going to hear, and which is exactly what they did. Typically, you keep it vague unless you have that evidence to present. And then you have options available. You can argue reasonable doubt, the lack of evidence, conflicts in the evidence, things like that. He didn't do that. And as a result, we got to hear Ashton raise that fact, and probably we'll hear it again in rebuttal.
And of course, when you refer to Ashton, just to remind folks, we're talking about the prosecutor there. And again, right now, we're minutes away from the Casey Anthony trial being back in session. They're on a quick lunch break that we expect to wrap up soon. The prosecution made its closing argument this morning. The defense started its closing argument when they returned from lunch. We expect the defense to pick up there. Bob Massi, I want to bring you back in and ask you, based on your work and your experience, although juries are completely unpredictable, how long a deliberation do you think that they'll make here? Because we're talking about a holiday, we're talking about people who have been sequestered. Any idea, based on the evidence and how this trial's played out, on how long they could take?
You know, Shannon, it'd be mere speculation. I would say this: I don't think the fact it's a holiday is relevant to these people. I think they recognize, regardless of how despicable maybe they think that the defendant may be and the tragedy of this beautiful little girl being gone, they are going to weigh the evidence, and that's their job, and that's what they're charged to do. Yes, it is a holiday. Yes, they would like to get home. But the most important part of their job now begins. They had to sit back and listen for the last 4 or 5 weeks. The interesting part will be the following. Who is the jury foreperson? That is a very important role. Most of the time what will happen, whether it be civil cases or jury cases, and I try mostly civil cases, particularly though in criminal cases and covering them, they'll take a poll immediately. They'll go in and sometimes they just say, where are we with this thing? You know, what's going on? The interesting part again will be, and I don't know what the policy is in Florida, and I would yield to the judge on this, sometimes they have what's called a reread, where if they are in a dispute on some factual issues, they will say, We want to hear some evidence again. And I suspect that Florida, like most jurisdictions, would allow that, where they have to go back into the courtroom and literally have to reread a particular testimony. Sometimes that's telling, but I got to tell you, if we were all smart enough to figure out a jury and how long would they take, we'd probably be doing something different once in a while anyway.
Yeah, we should start buying some lottery tickets. Well, Judge, let me have
sure.
you come in on that point about rereading and reconsidering evidence. How does it work in Florida?
It works exactly as Mr. Massi said. The jury can say they're not allowed to get a transcript to take back with them to the jury room. If they say we'd like to read the testimony of let's say, the lead detective, the judge will advise them, you can't have the transcript, but we will bring you out and read you the testimony. Sometimes they ask for a particular part, but usually the lawyers say, no, Judge, we want the whole testimony read, and if that's requested, that's what is done. The only time you read a small portion of it is if both sides agree that that's okay to do. So they'll be brought out, and the testimony will be read from the detective on that occasion on the stand completely to the jury, just as Mr. Massi stated.
And Shannon, I'm sorry.
Sure, Bob. Oh, I have a quick question for the judge, just because I'm curious, and I should remember this from the Florida bar exam, but that was a long time ago. Judge, I want to ask you, what is the reasoning behind not letting them have the transcript in their own hands? What are the concerns there, as opposed to bringing them all back into court and making the testimony be read in court?
Well, one of the concerns is you don't know that everybody's going to read it. You may have one juror who reads it and then summarizes for everybody else what was said. And that's also one of the concerns I had about the whole idea of opening the can that they called the can of death and passing it around. I guarantee you there are some jurors there who are not going to inhale that smell. And then you have some jurors who may comment on it, oh, that definitely smells like death, even though they may never have smelled it or how strong it was. And you have some jurors who never got to see that evidence. So with a transcript, you run that possibility that everybody's not going to sit there and read the transcript and pass it all the way around the room across 12 jurors. So you bring them out and you read it to all of them, and you know they all heard it.
And again, we're just waiting now for the jury to be back, for the court to return to session so that the defense can continue the closing arguments it began. Bob, I want to ask you, what does it do to the defense to break up in the middle of their closing argument and take a lunch break?
Well, I think it was a perfect time because if you remember, he sort of yielded to the judge. The judge, this is a good time to break. And I think, they regroup. They go to lunch. They talk about it. They say, how do you think how it's going? And they try to emphasize again some points, go back and sort of retract again and add to things of that nature. And the other thing, Shannon, I wanted to point out, I'm assuming these jurors had notepads that they took notes while they were in a jury box. Those notes are not evidence. And when they go into that jury room, sometimes what happens is, if you and I are jurors, I write down one thing that witness said, somebody else writes down what that witness said, and say, wait a second, that's not what I heard. Many times that's when that reread occurs, because the notes that were taken, for example, just people hear different things. And that's why this pool of people, I got to tell you, and the judge, listen, he has much more experience of sitting and listening to juries. There's never 12 more smarter people in the world right now than these people. It's amazing what they pick on. It's amazing what they make their decisions on. No matter how prepared these lawyers are, I will guarantee you, whatever they come in with, they will pick up on a few items and issues that no lawyer ever figured they would piece together the way they did. That's the miraculous part of this system.
And Judge, something interesting that they've got in this case that the jurors could see with their own eyes the entire time, Casey Anthony's family, her parents in the courtroom, as far as I could see for the majority of this case. And it's interesting because a lot of time people who are going to be witnesses or involved in a case can't sit in the courtroom, but this presented a little bit different of a situation.
It does, because Florida allows victims the right to be present in court. And so in this situation, they were able to be present throughout the entire trial. And that's something that can be brought up during closing arguments. You heard Baez bringing it up, saying, well, George sat here and he heard all the testimony. Even after he heard the witness say this, he took a stand and he said the opposite. It can be brought up by either party saying this is what he testified to, but remember that he was in the courtroom and was able to hear everybody's testimony. And if he chose to, he could have fashioned his testimony with that knowledge. It's just part of the risk and the reality that if a witness is allowed to go outside the rule of sequestration, which is a rule that says witnesses have to be outside the courtroom and cannot talk to each other, the flip side to that is the lawyers can comment on that fact and how it might affect their testimony.
All right, Judge Alex and Bob Massi, if you'll both stick around, we are now just waiting for the Casey Anthony murder trial to resume.